Welcome to topic number 2, in which we're going to be discussing the governing documents of common interest communities. A couple of words at the outset here. We're going to be covering several different things here. First, we will be talking about the nature of the properties themselves, and we will talk about how they are brought into existence using particular legal documents. And we will also be considering the way those governing documents are interpreted in the courts. And the laws in Illinois that we use for construing these documents are very similar to the laws that are used in many other states. So what I've tried to do is pull out several cases that are leading cases in how these documents are interpreted. Because if you practice in this area of law, or if you get involved with it in any way, you're constantly running into governing documents that need to be interpreted. They need to be understood. And so it's very important to understand the rules of construction. And also in those cases, you get some of the basic principles of HOA and condominium law that you probably want to know. So with that, then let's jump right into it. First thing we need to understand, I think, is a quick review on who the parties are here. Who would be your client and who are the players? First, when we say the association, we are speaking almost always of a corporation, a not-for-profit corporation. And so association lawyers, the people who call themselves association lawyers, are actually representing that corporation. They are not representing the members of the association. The members are something different, and often they get their own lawyers. So you have an association, and the association lawyer represents that corporation. What about the board of directors? Well, the board of directors and the officers of the association, they're the people who make all the decisions for the corporation. They are elected by the members. And it might appear that the board of directors are also being represented by the association lawyer. Now, often there's no division of interest, there's no conflict of interest between the board of directors and the officers and the association as a corporate entity. But it can happen. There are times when that happens. And if a conflict of interest arises where the board of directors are at odds with the corporation, then it may very well be the case again that the board has to get, or board members have to get their own attorneys. But that would not be the board as a whole, but individual members of the board might have to get their own attorneys. But the association is a corporate entity, and so the lawyer represents the corporation, and that's who they owe their duty to. Now, what about the members? Well, again, some people automatically think that the members are synonymous with the corporation. That's not the case. And it's strange in a sense because the members of the association are the owners of ultimately all the property of the association, except in an HOA where the association actually owns its own property. But even in that case, the members completely control the association and the property is all there for their use. But in reality, the members often have their own legal interests, their own legal positions, and they can get at odds with the association. And often this becomes a practical problem because members will call the association's lawyer and want to talk with them about something, assessment collection or some such issue. And this can cause problems because the lawyer is really representing what might be an adverse party in assessment collection or in a case involving enforcement of the architectural rules. It might be that the association and the member are really at odds with each other. So association lawyers have to be careful about that. Now, also, one more little bit of terminology here. There really are three kinds of property. I mentioned in the previous presentation, the individual interests and the common elements. There's a special kind of common element that we call limited common elements. And those are portions of the common elements. Let's say we have a condominium building. So we know that the individual interest is in airspace. And the common elements are basically the entire physical structure except for the airspace within each individual unit and the finished surfaces of the walls and floors. But in many associations, there is something we call limited common elements. And those are portions of the common elements, portions of the buildings, portions of the condominium structure that are in fact common elements, but they are limited in terms of who can use them. They are typically attached to one of the units, and they are reserved or limited in that sense to the use of the owner of that unit. So, for example, a deck, a balcony. Sometimes it might even be a parking space that isn't physically attached. But these limited common elements are often sources of conflict because there may have to be decisions made regarding maintenance or repair or replacement of that deck or that balcony, and there may have to be decisions made regarding the use of those things as well. So that can be a problem, but we'll discuss more of that later on. But just now understand the terminology. We've got the association, the board of directors and officers, the members, and then we've got the interests, the individual interests, the common elements, and the limited common elements. Now let's talk here about laws and governing documents and how they interact in general. Associations are created by documents. The documents are drafted by real estate developers or the lawyers who work for them, and they are recorded against all the units at the time the property is subdivided. Now, the fact, and in many cases, the documents can vary widely from one place to another. Now, jumping down to the bottom of this slide, this is where we have to draw a distinction between HOAs and condominiums. Homeowner associations are creatures of common law, and you will find this also explained in the Celeste Hammond piece that we looked at earlier. Homeowner associations are creatures of common law. They are brought into existence through the drafting of covenants that are attached to the deeds that go with the sale of property. These associations do not require statutory authorization to be brought into existence. They are brought into existence through the law of restrictive covenants, which is hundreds of years old. Condominiums, however, are not creatures of common law. They are creatures of statute. There was no such thing as a condominium until states passed Condominium Property Acts in the early 60s. It was impossible to create condominium ownership. It's really an artificial thing. The condominium is almost a fictional property interest that is very unusual in the Anglo-American legal system because each individual condominium parcel is not attached to the land physically, directly. It does not have its own little piece of the planet like a single-family home does. It sits on an individual piece of land, and we call it real property for that reason. Condominiums could be viewed as personal property or investment property, investment interests, but instead they are viewed as real property interests, and so we've had to create. And therefore, we've had to create statutes that describe the nature of the property interest and how it works. So the legal framework within which these developers operate in drafting these documents has to be covered in detail. There's several statutes. We are going to do that in unit number 3. But first, in unit number 2, today, we're going to talk about the documents themselves and understand that these documents embody most of the legal provisions that govern all associations. They also include the specific provisions that pertain to a particular document. And because of the difference between HOAs and condos, homeowner association governing documents vary much more widely than condominium declarations. And if you look particularly at old HOA declarations, if you get an old case from an association set up in the 60s, 70s, 80s, and there's a lot of them around the Chicago area, you may find all kinds of crazy provisions. Whereas the condo documents tend to be much more similar because they're much more tightly regulated by the Condominium Property Act. So these are the statutes that we're going to be talking about in Unit 3. I'm just mentioning it, referencing it right now so you'll get familiar with what they are. First is the Illinois Condominium Property Act. We call that the Condo Act for short. And then a more recently passed document or a provision of law called the Illinois Common Interest Community Associations Act. I'm going to explain to you a bit about the history about that, but understand this covers every association except condos. So basically, homeowner associations are governed by this. Before this act was passed, they were governed under a particular provision of the Condo Act called the Master Association Section. But now they have their own act. Third, we have the Illinois Condominium and Common Interest Community Ombudsperson Act. Now this is we'll talk about this. I was involved in drafting this legislation a few years ago. It's law, but the Ombudsman office has not been really established. There is someone formally in the position, but they aren't really doing anything yet because it has not been funded, and for a whole variety of reasons. And so we don't really have anything going on there yet, but be aware that it exists, because if it is funded and if it goes into operation at some time in the near future, it will be, this office and the ombudsperson will be a relevant issue and relevant concern for people who practice in this area. Fourth, the Illinois Code of Civil Procedure sections that pertain to forcible entry and detainer. Illinois is, to the best of my knowledge, the only state in the country that allows associations to collect overdue assessments through the use of forcible entry and detainer. In most states, it is done through the threat of foreclosure, and that's still available to Illinois associations. They certainly can and do foreclose if they aren't paid, but they are allowed literally to evict property owners as if they were tenants. That is, condos, yes, can go to housing court and they can start eviction proceedings for non-payment of assessments. And they can evict people from the property even though those people own the property. So that's a very unusual provision, but it makes it much easier for associations to collect assessments, because people don't want to be thrown out of their house, and it's easier to do that than it is to foreclose. Now, so let's turn to the governing documents. The most important documents, and really this pretty much covers the waterfront, are the Declaration. This is a very important document, and it goes under different names, but the Declaration, that's the number one thing we're going to be talking about. Number two, the Articles of Incorporation. I'm not going to have a whole lot to say about that. They're Articles of Incorporation of the association. Corporate bylaws. Sometimes they are in the Declaration. Sometimes they are a separate standalone document. And then there may be sets of individual rules and regulations for particular activities. There may also be architectural review guidelines. In some subdivisions, those things are separate. So those are the documents we're going to talk about. Okay, so first, the Declaration. This goes by different names. Generically, we call them usually CC&Rs. And when we want to talk about the author of the Declaration, which is the developer, we often call that person the declarant. And that you see that in judicial decisions, you see it in statutes, and you hear people use the term declarant. When they use the term declarant, they are referring to the author of the Declaration. And this Declaration is, in a sense, as often referred to as the Constitution of a given association. It has the basic legal structure of the association. It explains, that's where you find out what type of association it is. Because, for example, if it's a condominium association, it will say right at the outset that it is submitted to the provisions of the Illinois Condominium Property Act. So that's where the Declaration tells you what kind of association you're dealing with. It has the basic legal structure. It sets out all the powers of the association. It describes the property interests, who owns what. It sets out the various rights of the members. It is, again, it's a common law document. And if you remember from your real property courses, remember the term that a covenant or a covenant runs with the land? Well, these declarations run with the land. they are recorded against every single lot. And so if a person sells, unit 201, unit 201, if you check the records, you'll find a copy of the declaration right there. It has all the rights and responsibilities of ownership. It lays out the purposes and limitations of the association, why it exists. It contains, for example, general provisions in some cases, in some declarations, about providing for the general welfare and quiet enjoyment of the property of the people, etc. These words can turn out to be quite important. But now understand something. In an HOA, as I said earlier, because they're creatures of common law, you need to pay very close attention to the words of the declaration. Because a much larger range of association activities are determined by the declaration if you have an HOA than if you have a condo. Because any provision in the Condo Act, there's all kinds of detailed provisions in the Condo Act that are required to be part of a condominium declaration. Remember, condos are much more tightly regulated than HOAs. And for that reason, contrary provisions of the declaration are more likely to be found invalid because if they conflict with the Condominium Property Act. So that's important to keep in mind. Next is the Articles of Incorporation. These are executed and filed with the Illinois Secretary of State, just like they would be for any corporation. However, understand that a condo association is deemed by statute to be a not-for-profit corporation. This is part of that state regulation. A cooperative or an HOA, well, they aren't necessarily going to be incorporated. They will not be deemed incorporated by operation of law. And that can be very significant. I'm going to tell you about a case in a little bit called Scott versus York Woods, in which an association learned the hard way about this. You see, all not-for-profit corporations, of all types, are supposed to file an annual reporting form with the Illinois Secretary of State, in which it's a very simple form. It simply tells you whether, who the directors are, the president, the treasurer, the secretary, the address of the corporation, the agent for service of process. Very simple form to file. Has to be done every year. A cooperative or an HOA, and if they're incorporated and they don't do this, they can be involuntarily dissolved. And if they go more than 5 years without reincorporating and getting reinstated, not reincorporated, but reinstated, they can be perpetually dissolved and never recreated again. And this can be a real problem. So it's one of those things to keep in mind. I always tell people, whenever you take on a new client, and it's a not-for-profit corporation, HOA or otherwise, the first thing you should do is check the Secretary of State's website to see if the association is in good standing or not. See if they have filed the reporting form. Because I have done this in the past and discovered that, for example, a not-for-profit association that I represented for a while had been involuntarily dissolved before, and when I took over representation of it, I checked that, and sure enough, I had to get them reinstated because the previous attorney forgot to send in the form. So it's easy to do, and just a word to the wise. Always check that and make sure that they stay in good standing. The bylaws of the association, those are the organizational structure, the day-to-day rules for operating the elections and other things. Some of this could be duplicative of what's in the declaration. As I said, sometimes it's actually the bylaws are included as a separate part of the declaration, like Article 6 or whatever. But understand that this is important because, as I said earlier, if they are incorporated but they lose their corporate status, then it may turn out to be the case that some of the provisions of the bylaws become unenforceable. So, and also every year, ideally, this is what most attorneys recommend, every year associations should review their bylaws. Certainly, no they shouldn't wait longer than 3 years. But ideally, every year they should review the bylaws and see if they need to have them revised and see if they still make sense and if they work for them. Rules and regulations that cover specific issues. This is pretty common. Many associations will have a special set of rules, a standalone document for certain issues that are deemed necessary by the board of directors. A very common one is pets. Especially, there are quite a few Chicago condominiums that have detailed sets of rules and regulations regarding pets. Normally, understand this, that these rules and regulations are not part of the declaration. The rules and regulations are emanate from the board of directors, and often the board of directors will have the members vote on them and approve them by vote. But these do not have the legal status of the declaration. The declaration contains a very, very high presumption of validity. That is not necessarily true of rules and regulations if they're written badly. We're going to talk about this when we discuss interpretation in just a few minutes, but understand the rules and regulations, certainly they're generally speaking enforceable, but they don't have quite the status of the recorded declaration. And one reason for this is that the law presumes that when you buy a piece of property, you buy it subject to all the limitations that were originally imposed on the property at the time of subdivision. And later, 5 years, 10 years later, the board decides to make modifications. Those don't have quite the significance of the original recorded property rights. So keep this in mind. There also are often more detailed rules about parking, especially in a place like Chicago. They may have more detailed election rules than are in the bylaw. Normally that's prescribed in the bylaws, but they may have some detailed provisions about how to, so that a property manager and residents understand what's supposed to be happening. And there, last common topic for particular sets of rules and regulations is architectural review. Now, this is probably more common in HOAs than condos, especially where people live in a suburban or exurban house, and it is assumed that they will want to put in basketball hoops or paint their house this or that color, put up a certain type of fence, do something with their driveway, or what they call hardscaping. And so associations, of course, if there is an architectural review power, which there almost always is, the board may decide to draw up some architectural review guidelines. Now, are these rules? Well, sometimes they are, but often they're guidelines. In other words, the board is telling people in advance what they are likely to approve and what they are likely to not approve. And this becomes important because, as you will see when we talk about architectural review, potentially boards can have a great deal of latitude in making these decisions, and often in order to avoid, to create some predictability in the membership, the association directors voluntarily, so to speak, draw up guidelines, and they say, look, these are the types of things we're likely to look at if you ask for permission to put up a fence, or a basketball hoop, or a boat dock, or something of that sort. They may be very detailed. Often they'll specify materials, colors, dimensions, even particular brands for modifications to existing structures. And it's very likely if you go into a subdivision where it's still being built, where the association board of directors has the right to approve the architectural plans for a newly constructed house. That's a big undertaking. Well, often there will be guidelines for that. Lot size. Floor size. 1,800 square feet for a split level, 2,000 square feet for a two-story, etc. And then more detailed provisions regarding roof materials, wall materials, what the driveway has to be made of, etc. So this is fairly common, and again, these are rules. Now, again, if this is in the declaration, if these things are in the declaration, they're given a very, very high degree of deference by courts. And if they're not, then they're usually reviewed on the basis of whether they're reasonable or not. So now we're going to turn to talking about some really important cases. These are Illinois cases, and they address the question of how to interpret the governing documents of an association. Now we're going to talk about some other cases, particularly when we deal with document amendments. But these are, we're going to have a whole session on that. There's some really interesting cases there as well, and those deal with interpretation of governing documents as well. But these cases lay out some really basic, important principles. These are all Illinois cases. Two of them are Illinois Supreme Court cases, Watts versus Fritz and Porras versus Lake Holiday POA. Those are Illinois Supreme Court cases. And the others, two, Amico Realty and Scott versus York Woods, are from the appellate courts. So let's begin with Watts versus Fritz. This is 29 Illinois 2nd, 517, a case from 1963. This case is cited all the time in cases where there's a dispute over how to interpret a declaration. Now, what happened was this man named Roy Watts decided to re-subdivide his lot so that you could have an additional house built on it. Now, this I have actually run across. I've actually had a case an appellate case that I had to address this very issue. This actually happens. Re-subdivision means you're on a lot and it has a certain size and it's lot number 123, and then you apply for permission to turn it into two lots. And so then there would be potentially two houses, and this can greatly increase the density of a subdivision, obviously, if everybody did this. And now some declarations contain an express provision that says you may not re-subdivide your lot. In other cases, they don't. And so then we get into the question of, should it be, if there is no express prohibition on re-subdivision, is it permitted or not? So what happens here is Fritz, another unit owner in the subdivision, sues. And he says that in his opinion, the declaration prohibits re-subdivision. Now, ultimately, the court interpreted the declaration and they ruled that it did not prohibit re-subdivision of the lots. And that's an interesting rule, but I think the reason we read this case is for its lengthy discussion of how to interpret restrictive covenants in declarations. Now understand that this is an old case, and one reason I'm showing you this one is because they look at it differently in 1963 than they do today. This is an old case, but it's still good law. But just understand the rule in this case has been modified a bit over time as covenants have become more favored by the Illinois court. So what you have here as the basic principle of covenant interpretation is what we call the rule of strict construction. And the court says, and this is because they're finding no express prohibition on re-subdivision. They say that the primary purpose of the construction of a deed, the interpretation of a deed, is to ascertain the intention of the parties. Now, how do you do that? You do that by, he says, giving effect to every word and rejecting none of the document, as long as you can do that without violating any positive rule of law. So the documents are, the original recorded documents are presumed to be valid as long as you can't find a violation of a specific rule of law. Now often though, you end up in a state of some uncertainty or doubt as to the meaning of words, as to the meaning of phrases. How do you resolve those doubts? Well, this is where you see a difference between the older cases and the newer cases. Because in the older cases like this, it says that you should resolve the doubts in favor of, quote, natural rights and against restrictions on, quote, natural rights. By what they're talking about is the free use of the property. Now understand, 1963, there were virtually no condominiums and very few HOAs in the state of Illinois. There were restricted properties, there were racial restrictions and all sorts of things. But this is before the common interest housing boom came along. And what really changed over time was courts began to take a much more favorable view of restrictions. They began to move away from this resolving doubts in favor of natural rights idea, moving toward recognition that common living requires some restrictions on individual liberties. And they also took the position that minor violations of a restriction will not prohibit the subsequent enforcement of it. Now, this is a very important provision, rule in this case, and this has not changed. This is the law in this state and almost every state. It is often argued when an association attempts to enforce a restriction, the homeowner will say, well, wait a minute. You haven't enforced this in the past. You didn't enforce it against Joe Blow. You didn't enforce it against Mary Jones. And now you want to enforce it against me. You have waived the right to enforce the provision by not enforcing it. And for a long time, associations were so afraid of this that they would engage in very rigid rule enforcement. I mean, petty rule enforcement, to avoid having to run afoul of this waiver provision. But in fact, that really is a misinterpretation of the law. I mean, lawyers have often given that advice, but it's bad advice, because it is bedrock law that minor violations of a restriction that go unpunished will not prohibit the subsequent enforcement of the law. There has to be acquiescence in prior violations of the very substance of a general plan or particular restriction. In other words, it has to be clear that over a period of time, an association just acquiesced in a whole series of violations of rules, and the violations went right to the heart of the rule. In other words, they were flagrant, clear violations of a clear rule. And if there's a pattern of failure to enforce like that, a pattern of failing to enforce clear violations of a clear rule, then there could be a case for waiver. But if all you have is minor violations or quibbling, arguable violations, that is not enough for a case of waiver. But understand that this case, this Watts case, is the older view. It's not that it's been overruled; it hasn't. But there's a kind of suspicion that you find in here, sort of a suspicion of covenants, which reflects the old English view of these deed provisions. The old English view was that, and still is, that restrictions on the alienability and the use of real property should be viewed with suspicion because they are presumed to impair potentially the value of the property, and they didn't want property to be worth less as restrictions were added to it. But in our system, our legal system, we have increasingly come to view restrictions as enhancing property values. So they really aren't viewed with the skepticism that they once were viewed. So here's Watts versus Fritz. Take a look at it. These cases are all in your readings if you want to look at it. It's not very long. It's pretty simple and easy to read, and you can see the descriptions of how to interpret the declaration. Now we jump ahead here. Amico Realty versus Montalbano, 133 Illinois, Ill-App 3rd, 327. That is from 1985. And here we see the doctrine of strict construction of covenants limited by a more of a focus on the party's intention and the obvious purpose of the restriction. So they're moving a little bit away from the words and toward a larger factual analysis of what the parties actually intended. So what happened here? Well, the developer tried to enforce covenants that restricted the property's use to residential purposes only and prohibited any structure that would obstruct the boundaries or delineate any boundary. So that's not the important part. The important part here, I don't want to get into too much. This is a property out in DuPage County. I just want to focus on the way they interpret the declaration. What it involved here was some light posts that flanked the entrances to people's driveways and were on the boundary line. And so there's a long factual discussion of this. But in the opinion, you'll find some really clear language about how to interpret these declarations that is often cited, and I would refer you to if you're in a case where this is an issue, that is interpretation. the Montalbano said, oh, this restrictive covenant that affects the light posts, it's vague, it's ambiguous, it's enforced arbitrarily and not uniformly, and the term delineating a boundary line was not defined. What the heck does that mean? And the court said, the paramount rule for interpreting covenants is to expound them so as to give effect to the actual intent of the parties as determined from the whole document. You read the whole document, take it as a whole, and then you construe it in connection with the circumstances surrounding the execution of the document. How was it done? Why was it done? Where was it done? What was the purpose of it here? They say the rule of strict construction in favor of the free use of property will not be applied to defeat the obvious purpose of a restriction, even if it is not precisely expressed. So, as it says, before giving effect to the rule of strict construction, the courts will have recourse to every aid, rule, or canon of construction so as to ascertain the party's intention. So in other words, this involves the court in trying to figure out what was the lifestyle that was anticipated here. What did the drafters have in mind? What does the original document, what did the original parties, so to speak, intend the document to mean? And with respect to the restriction that is at issue. And so it says that the generalization that all doubts and ambiguities should be resolved in favor of free use and against restrictions cannot be used to ignore or override specific language of a restrictive covenant. So go back to Watts versus Fritz. You see that that sense that the natural property rights are the most important thing. What you find here is that the intent of the parties is the most important thing. And so understand the parties in this case, this is kind of a fictional thing. When we talk about parties, it's a strange thing because think about when the document was recorded. Who were the parties? Well, it was the developer contracting with himself or herself. You see what I mean? Because there were no owners. The developer drafts a set of governing documents and imposes them on the subdivision, and there aren't any owners because other than the developer. The developer owns all the units. The developer is the grantor and in a sense the grantee. The developer is the declarant and also in a sense the property owner of all these. So the developer is imposing restrictions literally on the developer's own properties. And then after that they simply they run with the land to all the subsequent purchasers. So this whole thing about the party's intention is really the developer negotiating with the developer. But what we are looking at is what was the plan? What was the purpose? What was the property for? And we don't emphasize quite so much the natural property rights of the parties. And once again, we see reaffirmed here, minor violations do not establish a pattern that justifies waiver of a restriction. This waiver argument, which is made all the time, really takes it takes a lot more evidence than many people realize. One or two minor exceptions, arguable exceptions, are not enough. You need to show they have failed to enforce clear violations of a clear rule over time. Now, Scott versus York Woods, I think, is a very interesting case. I think this is interesting in part because what we have here is an old association. York Woods was built back in, was incorporated, the original association was incorporated in 1962 and 63. It's an old association. And they made a big mistake. First, they were involuntarily dissolved by the Secretary of State, but they did not know it. They did not know they had been dissolved. They were dissolved in 1988. This is, the 2002 case. So in 1988, they were involuntarily dissolved. And this is just a mistake made by whoever was representing the association. They, if you don't file your not-for-profit corporation information form every year, you will eventually be involuntarily dissolved. But here's the problem. If that happens, you have 5 years. Under the statutes, you have 5 years to get reinstated as the previously existed, as the dissolved corporation. It now becomes a corporation in good standing. It's not a new corporation. It's the old one reconstituted, recreated, revived. Now what happened here was, it's very complicated facts, but in essence, the old association existed from 1963 to 1988 when it was dissolved, but nobody knew about the dissolution until 1997. So before it was 9 years. 9 years had passed before anyone even realized that this was wrong. And what happened was they had just hired an attorney, and the new attorney did what I told you should do when you get any new non-for-profit corporation client. He checked the records, and he found out, oops, they've been dissolved. So what does he do? He tries then to file to recreate the old corporation, and this is difficult. The problem here is that. It gets very, very factually complicated, but the vast majority of the owners wanted to do this. It was 113 to 66, and they clearly wanted to do it. But unfortunately, they tried to do this too late. You can't, no matter what people want to do, you can't revive the old corporation 9 years after it was involuntarily dissolved. So what we had here was when they reincorporated themselves as a new corporation, not a reinstatement or a reincorporation of the old association. So that's a really important provision. Keep that in mind. And that's important because it has to do with the ability to enforce the original governing documents. Now, we have a further issue here, and this is where the need to interpret the declaration comes in. The declaration contained what's called a window for amendment. We call that a restrictive window, and this one was particularly harsh. And I've seen many of these. This is not old associations watch for this. If the association wants to do an amendment, pay particular attention to this, because old governing documents of old HOAs often have a restrictive window that say, for example, you must wait 10 years, for example, from the original incorporation or the original adoption of the declaration. You must wait 10 years, and then they're open for amendment for 1 year, and then they close again for another 10 years, and things of this sort. Now, the point is not to memorize what happened to Scott, to the particular provisions at York Woods. It was complicated, it was harsh, and you know what? Back in the 60s, that's what they did. It was very common that they did this. The developers did not want people willy-nilly amending documents, and so they would put these harsh document amendment windows in there. And here's the moral of the story. They are valid and will be upheld unless the party challenging the document provision proves that they are, 1, wholly arbitrary in their application, or 2, violate a public policy, or 3, abrogate a fundamental constitutional right. So when you are looking at declarations restrictions on the use of property, the original documents carry a strong presumption of validity and will be upheld unless they are arbitrary, violate a public policy, or abrogate a fundamental constitutional right. Now, this is the other interesting thing about this case. What is the relationship between the corporation and enforcement of the governing documents? Understand that the property documents, the deed restrictions, those run with the land, regardless whether the association is incorporated or not. The associate, and often, and it is generally the case, individual owners have the right to enforce the governing documents as well. They have the right to enforce at least restrictions on the use of property. So sometimes you can see lawsuits filed by the individual owners. That's not the problem. The problem is that the association, in this case, is in bad standing because it isn't the original association. And this causes some terrible, terrible complications. So if you're interested in reading about this, you can read the decision, which is in your materials. But understand, if you want to invalidate a provision of governing documents, you have to prove that the provision is arbitrary, violates a public policy, or abrogates a fundamental constitutional right, and that's pretty tough to do. Other than that, you're going to have to interpret it. So, ordinarily, your challenge to documents has to do with interpreting them, because invalidating them is a really tough thing to do. Last case, Porus versus Lake Holiday Property Owners Association. I think this is an absolutely fascinating case. This is a 2013 Illinois Supreme Court case, remarkable situation, in which Ken Porus, who is an attorney, was a member of the Lake Holiday POA. It's a beautiful lake property out in the western suburbs. He sued the association, the board of directors, and everybody else he could find for a whole variety of things, including false imprisonment. Now, this is a lake community, 1,500 acres, 2,000 lots, big development, been around since 1965. It's in LaSalle County, in unincorporated land. Now, again, this is I'm not going to go through all of it, but basically here's what happens. He is driving down the street one night, coming home from work in the evening, and he sees flashing lights behind him that appear to him to be a police car. He pulls over. He's approached by an officer in a uniform carrying a big flashlight and a uniform, a badge, and no firearm, but he didn't notice that really. But he had certain types of weapons on a duty belt. He looked just like a cop. He asked for Porus's driver's license, took it, walked back to his car, and then when Porus started to get out, the officer told him to get back in the car. Well, pretty soon Porus realized that the lights were not red and blue, they were yellow. And he began to wonder if this was really a police officer, and he said, "Wait, are you a cop?" And the guy said, "No, I'm a security officer for the POA." Well, and Porus, being an attorney, challenged this. He took it all the way to the Illinois Supreme Court. Fascinating case. He won in the appellate court. He lost before the Illinois Supreme Court in what I personally think is a very poorly reasoned decision, but so be it. The association, according to the Illinois Supreme Court, was not unlawfully exercising police powers by doing this. What were they doing? They were enforcing rules and regulations, acting within their authority as a voluntary association to enforce rules and regulations with respect to association members. Well, and they analogize this to the Kiwanis Club or the Rotary Club or something, and saying, well, if you don't want to like the rules of the association, you can always resign from the association. Well, of course, you can't. Homeowner associations are mandatory membership organizations. You cannot resign from a condo or HOA association. You can't do it. The only way you can leave the association is by selling your property. All these associations are automatic membership associations. So there's no way for him to just leave. He lives there. And I think this is a very interesting one. It also says that courts generally will not interfere with the internal affairs of a voluntary association unless there is mistake, fraud, collusion, or arbitrariness. So once again, the rules and regulations are generally presumed to be enforceable. And I use this example because this isn't just about the property itself. This is a behavioral rule. These association members are required by their rules to pull over their cars and to be questioned, to surrender their driver's license, to identify themselves. Those are the rules of their association. And the Supreme Court says they're totally enforceable. They're not a violation of any restrictions on the use of the police power by civilians. It's totally okay. So that's quite a significant case, and I'd ask you to keep that one in mind as well. Those are the main cases that I think you need to be aware of. So let me just try to see if I can summarize this. First, association governing documents are enforceable in almost all cases. They may have to be interpreted, we'll talk about that, but they're enforceable. The old rule that held them in suspicion has been replaced by a newer view that they are enforceable, even if they appear to be harsh, even if they appear to be somewhat unreasonable, as long as they are not arbitrary or illegal or violate a public policy. So ordinarily, you're down to interpreting the rules. How do we do that? Read the whole thing. Take the document as a whole, the declaration, the bylaws, take it as a whole. Figure out and argue from the standpoint of the intention of the parties. What type of property was this? How did this proposed property use or whatever you're arguing about fit in with that intent? And apply the document to the facts of your case with all that in mind. So that's it. That's run through on governing documents. You have in your folder examples of all these governing documents. I'd suggest that you read them over, use them, and understand what goes in them. Our next session, unit number 3, we're going to talk about the requirements of the law, and when we do that, that means the Condo Act, the Common Interest Community Associations Act, etc. When we do that, we will be once again talking about the contents of documents, because those acts say what must be in the documents. But now we've covered the documents and what they are and how they're interpreted, and we will turn next to the issue of what detailed provisions must be in them, and how to understand them. So that's all for today.